Hello, and welcome to Marino Bar Review's July 2025 Bar Exam Predictions Lecture. My name is Michael Marino. I am the third generation of my family to help students prepare for and pass the bar exam, and I really appreciate you taking some of your final moments studying and spending it with me. Now, the goal of this video is to help you prepare for the bar exam, obviously. I'm going to do my best to let you know what you're very likely to see, what you're unlikely to see, how you might see it, and then I'm going to try and point you towards a past essay. Remember, all the essays on the MEE are available on the bar examiner's website to help you get a sense of ways some of these rules are tested. Trying something new here, point you in some sort of direction. The first thing you're probably wondering is why you should be spending this time with me, other than the general desperation of wanting to know what's on the exam. As I mentioned, my family's been doing this a long time, since the 1940s. My grandfather created the very first commercial course, and in fact, through a series of mergers and acquisitions, eventually became Barbary, which I'm sure you're aware of. My father followed in his footsteps. He eventually had the second largest Barbie course on the East Coast. Famously, he helped get JFK Jr. to pass the bar exam. I know they're doing a mini series. JFK Jr., he had failed twice before with other competitors. He eventually came to my father asking for help. My father said, "Hey, you come live with us for the summer." So JFK Jr., when I was about 9 or 10 years old, lived in our house while studying for the bar exam. I mentioned they're doing the mini series. I'm hoping, that I'll be a character in it, though. At 9 years old, I looked a lot like Pugsley from the Addams Family, so maybe they will hopefully skip that part. My father also famously created IRAC, issue, rule, analysis, conclusion. So you can imagine it was a lot of fun growing up in my household. I've been doing this for 15 years. I took our business online, created what is now the only course designed specifically for people who failed previously. If you're watching this video, you're very likely to pass. I'll tell you a little dirty secret of bar review that all bar review courses know, but they don't like to share, is that bar review doesn't help you pass the bar exam, at least relative to your peers. People tend to graduate in GPA order. If you went to a top law school, you finished at the top of your class, congratulations, counselor. You are extraordinarily likely to pass the bar exam. If, however, you went to a mid-level law school, finished maybe middle of your class, well, you have some challenges. And the problem is, if everybody's taking one or two of the same courses, there's no comparative advantage. There's no ability to get you over the hump, so to speak. And that's something we've recognized. Also, I think that people misunderstand the bar exam. And I'm not much of a salesman, but I'm going to do a little sales pitch here, so please bear with me. But I think people misunderstand what the bar exam is all about. Many people, and I think many bar review courses, see it as some sort of be-all, end-all final exam, or maybe some sort of hazing ritual. And it is, on some level, a hazing ritual. But it's not a final exam. It's a test of proficiency. It's a test of, does this applicant, does this exam taker have the requisite legal knowledge, and can they apply that legal knowledge in a fact pattern, a real life-based fact pattern? That's a skill. It's a skill that they don't teach you in law school, and they don't teach you in bar review. In fact, it's in the name. What they do in bar review is review the law. It's a great way to freshen up. Like I said, if you're at the top of your class and you just need a reminder on some of the law, that's great. But you don't want to review the law. In fact, the bar exam doesn't even test law. The bar exam tests rules. And that's sort of the basis of what we do here at Marino. We help you with real-world exam skills, real-world exam law. We try and teach you the law, how it will appear, not just review the law in general. And when it comes to people who've taken the exam before and failed, we help you formulate a plan for the second time, valuing your time with the skills you already have. We also run the largest bar exam tutoring company in the country. We do everything online. We try and be as reasonably priced as possible. Bar exams, or rather tutors, it's not remedial. It's the idea of getting a personal instructor to help you get through and make sure you're doing the best you can. You don't want to do this twice. If you have to do it twice, that's what we're here for. Regardless of whether you want to use our services or not, we offer free score report evaluations. Take advantage of that. We enjoy this. I like being a lawyer. I want more people in the club. So whatever I can do to further that, I'm happy to do. Also, if you are successful, we run the Marino Institute for Continuing Legal Education. You're going to need credits to keep up your license. We run the largest Bridge the Gap program in New York, but we are around the country. So if you enjoyed this video, please check that out. There's information below at the end of the video, but you can go to marinolegal.com, marinobarreview.com, marinolegalcle.com to find out more. But that's my sales pitch. Now let's get to why you're here. And the first question you're probably asking is, what's the point of this video? And let me do my best to help you understand how to use this video appropriately. By now, you should have a study plan. You should have a schedule mapped out for your remaining days. You should know what to do. And there should be no laws or rules that you just haven't heard of before. There's nothing, certainly in this video, that's not in your notes. I don't have a secret rule. I don't have a secret subject area being tested. But what I do have is knowledge of how the bar examiners think, a deep understanding of the bar exam in general, and the history of the bar exam over the past, well, really since the MEE, the UBE began. So what I'm going to do is go subject by subject, give you some areas to discuss, whether it's likely to appear or unlikely to appear, and then I'll point you to maybe an essay that you can go back. Like I said, everything's available online on the Bar Examiner's website. If you are a Marino student, you have access to all these essays already. If you have any questions, you can always contact our office. But let's get right into it. First and foremost, Conlaw. It's reappeared after a very long gap. It showed up on the last two bar exams. I would expect, given the uproar and the focus on the Supreme Court, that they're going to continue to test Conlaw. I know that's not something everybody wants to hear. What do they like to test? Well, I want you to focus in on state and federal interactions. That includes the Dormant Commerce Clause, sovereign immunity, and the Equal Protection Clause. Okay, you're very, very likely to see this sort of essay. The First Amendment, freedom of speech, it was just tested, so it's probably not likely to be tested again. But make sure, just in case, you know your public forum rules and scrutiny levels. Certainly the MBE will be testing this, so make sure you're up to date on that stuff. Lastly, the Establishment Clause. We don't use the Lemon Test anymore. If it's in your notes, don't do it. Instead, we apply the historical practices, the coercion endorsement analysis. If you're a Marino student, that's in your notes. A good example from a past essay, if you go back to July of 2017, there was a state law that required a biometric ID for large transfers. An out-of-state bank challenged it under the Dormant Commerce Clause, and the state argued sovereign immunity. A great interplay there. You can see the essay, you can see a model answer, you'll get an idea. It also explored injunctive relief, something that they like to tack on to these essays. Great practice for that state action, federalism, and equal protection themes. If you're likely to see some sort of freedom of speech, Establishment Clause, I point a lot of people towards an essay from California from a few years ago. A student at the top of the class is doing great. The school, in order to curb gang violence, bans anyone from wearing the color green because that's the color of a gang. The valedictorian who was doing well wears green one day, gets suspended, and now there's a whole bunch of questions of did the school go too far? What's the level of scrutiny? And also in that case, mootness, right? Because by the time the student's case was heard, they had not only passed high school, they'd graduated college, they were in the workforce, etc. This is how you can see these things. Conlaw likely to be tested. Don't skip it. Crim law. Crim law, often tested with criminal procedure and evidence. I'm going to talk about sort of all three here back to back. Crim law itself has not shown up since February of 2022, so it is due. I think it is very ripe. I think that you're unlikely to see a straight crim law evidence essay. I think you're very likely to see it combined with crim pro or evidence. For crim law, though, make sure you study the homicide degrees. Make sure you know those affirmative defenses, duress and insanity. Conspiracy, big thing that's tested, and accomplice liability. They love to test these things. A great way that they do test that, if you remember, is the basic essay that they love to do where two people get together and they say they're going to rob a convenience store. They agree at the time, no guns, but sure enough, on the way to the crime, one of the guys takes out a gun and says, "I'm going to use this." The other person says, "No, no, no, don't use it. I want to withdraw from the conspiracy." But sure enough, during the incident, there's shootout. Maybe a police officer sees, and the police officer shoots a bystander out of all this, or maybe the police officer shoots the bystander and one of the accomplices. And now the question is, conspiracy, did they properly withdraw? Can it be charged with felony murder? That's a very classic fact pattern. You see it often. I want you to know that cold. You're going to see questions like that on the MBE at the least, but that could be a whole essay right there. So make sure you understand that. Crim Pro, Miranda warnings, obviously, the Sixth Amendment right to counsel, specifically when it attaches. Maybe they stop somebody on the street. Maybe they pull them out of their car. Is this a stop? Is it an interrogation? Are they in custody? Understand that. And then grand jury. Grand juries, you may pass it over when you're studying because you feel like it's not testable, but they do test it from time to time. So make sure you're familiar with those rules. And then in evidence, character evidence, hearsay exceptions, and relevance. Just simply saying, by the way, all evidence must be relevant in the first place to be admitted. That's worth points, but character evidence and prior bad acts, prior convictions, this is the type of stuff they love to test on. So I want you to be familiar with all of that and how it interplays with crim law itself, because this is how you're going to see it. A good example, we can actually go back to the 2022 exam. There was a gang shooting case, required analysis of expert testimony by a detective, and whether a former gang leader could identify the accused using tattoos. This tested Miranda, it tested hearsay, it tested the Sixth Amendment, and that balancing that probative value with a prejudicial effect under the rules of evidence. That's a great essay to go back through, read the model answer, get familiar with it. I could see something very, very similar coming again. Similarly, civil procedure, okay? That's something that it's tested often. It's tested frequently, and it was tested on the last exam, and I think it will be tested again. It's a tough one, along with Conlaw, things that are more abstract, but in this case, really focus on that personal and subject matter jurisdiction. Understand venue and the change of venue, forum nonconvenience, and also, while you may be tempted to skip over preclusion, res judicata versus collateral estoppel, that is ripe for testing, and it's something that they love to throw in. Good example of this kind of essay, if you look at February of 2018, a plaintiff sued a moving company in federal court. Service of process was challenged because it was made at the defendant's parents' home. That essay tested validity of service, diversity jurisdiction, and the relation back doctrine. These are things that are ripe. It shows how jurisdictional and procedural issues intertwine. Love that essay. I think you could see a repeat of that and those issues. I'm feeling pretty good about that prediction, so make sure you go back over and take a look at that essay. Contracts. So it last appeared in the last exam. It appeared with torts. I think you're likely to see it rotate back in. Usually they switch off torts and contracts, and then last time they tested it together. But I think if you're likely to see one or the other contracts, I'll talk about torts in a second, but no contract formation. Understand about performance and damages, especially the parole evidence rule and modifications. Good example also from that 2018 exam, there was a potter who entered a contract for both services and goods. She later claimed an oral modification and price adjustments. That tested the predominant purpose test, the parole evidence rule, the UCC versus the common law modification rules. They love these types of things. You're never going to get a straight contracts essay. They love that idea. And also understand with contracts, the idea of like a common carrier rule, if I ship something, knowing the rules, how it differs there, because obviously it's going to get destroyed in shipment. You should always be thinking ahead when reading these essays. Like I said, go back to that 2018 exam. Great contracts essay that I think is likely to be tested again. If they do test torts, usually it's going to be tested with agency. Um, Remember negligence, vicarious liability issues. The obvious two big ones there are, a bouncer at a club injuring somebody, or on the other one, a delivery guy stopping to get a cup of coffee or pick up his dry cleaning on the way home, and a accident happens. So understand that. Make sure you know trespassers versus invitees versus licensees. That is a big one. It was tested not that long ago. A great version of that, just as an example. Um, Somebody owned a piece of property. He knew that kids like to go sledding on it. Didn't invite them to go sledding on it, but he knew they were there. Sure enough, a kid goes sledding, gets injured. Now the question is, what was the status of the land, and what was the duty that, as the landowner, owed to that person? You may know them as trespasser, but they were a known trespasser, right? That's a great essay question because they can test different ways. Maybe multiple people get hurt, entrance on the land in different scenarios. So no trespasser, invitee, licensee. The other thing likely to be tested, products liability. They love products liability. It's a fun one for these examiners to write essays on. So really go understand products liability there. If agency comes up, know apparent versus actual authority. And like I said, when vicarious liability applies. When we talk about apparent versus actual authority, I give this example a lot, but I think it's the best way to really think about it. There is a junior associate at a firm. They are at a firm party for clients. The senior partner introduces the client to the junior associate and says, this is so and so. They hit it off. They decide they're going to do some sort of case course business together. The junior associate hands a business card, and on the business card where it says associate, it's crossed out and writes partner. They enter into a contract, and now the question is the firm liable for that contract? So that's a question of actual versus apparent authority, whether they should have known. Great essay question, great fact pattern. You can look back into the July of 2018 for a good independent contractor versus employee essay. In this case, an independent contractor built a fence, injured a trespasser. The question then is whether the contractor's employer could be vicariously liable. You look at negligence versus strict liability. Great essay at that torts agency crossover and the scope of employment. That's the type of essay I think you're exceedingly likely to see if you do see torts. But again, my money is on contracts over torts. Family law. It was last tested last July. But before that, it wasn't tested, I think it was 2021. So I think it's ripe. If you do see family law, though, my guess is it's going to focus on that child custody support, spousal support, third-party custody, the idea of grandparents trying to get custody. Previous essay, divorcing couple, they split, now they're across state lines. Grandparents seek visitation, so you have to understand custody jurisdiction, that's the UCCJEA, and the support enforcement, UIFSA, and then parental fitness. But I do think grandparent custody is, out of all of the possible obscure rules, the one that's most likely to be tested. So go through it. Worst case scenario, it's 5 minutes out of your day, but I think this could be worth points on the exam. Related, and on our final sort of subject for this, decedents, estates, and trusts, it appeared in February of 2025, so that's the last exam. It's an often repeat subject, though. So if you see it, it could be tested alone or with trusts. Make sure you understand will formalities. Is this a valid will? Is this a valid codicil? Did it have the correct formalities? Understand holographic wills, revocation. Specifically with revocation, though, pay attention to partial revocation. And then testator capacity, undue influence. That's something that's come up quite a bit in the past year in the appellate courts. So my guess is the examiners are keenly aware of the idea of undue influence and capacity issues. So just pay attention to that and know the rules specifically and the exceptions to those rules. If you are looking for a type of example that you could see, you can go back to the July of 2017 exam. That's quite a bit of ways ago, but there was a handwritten will that gave specific gifts and created a trust. Later, a codicil raised questions about whether the original document had been properly incorporated. it was a great essay for testing incorporation by reference, codicils, and then mental capacity. But creating that sort of trust in a will is something that they like because it can combine both subjects. But this is my best guess as to what you're likely to see, how you're likely to see it. There is still plenty of time left. So I encourage you, don't give up, keep fighting harder. If you feel like you need extra help, come to us. We have tutors. There's a lot that can be done with just a few hours and getting you straight. If you're in our course already and you want to add tutoring hours, just contact the office. It's pretty simple to do. But I am excited to welcome you to this club. I appreciate you spending this time with me. Good luck. If you're successful, congratulations. Please look at our CLE courses. If you're unsuccessful, do not stress. Send us your score reports. We will be more than happy to help you out. Now, get back to studying. Good luck. I will see you soon, counselor.